Good afternoon, everyone. Thank you for joining us today for our webinar series, Legal Planning for Specialty Crop Producers. My name is Chloe Marie. I am a research specialist at the Penn State Law Center for Agricultural and Shale Law, and I have a few housekeeping notes before we begin. So first, please note that this webinar is being recorded. All registrants will receive access to this recording as well as recordings of the other presentations in our series. Check the bottom of the reminder email that you received from Zoom to find the link of the prior recordings. And you will also receive another email with the link to this recording once it is available. If you have any questions during this presentation, please put your questions in the Q&A and we'll make sure to save some time at the end to answer them. And to get a copy of this PowerPoint, check out the event page on our website. And as we're getting started, I would like to provide a little background on the center's organization. Our director is Rose Pfeiffer, Jackie Schweckler, Audrey Thompson, and Brook Duer are our staff attorneys. And in a couple minutes, you will meet Brook Duer. So here at the center, we provide numerous resources for agricultural legal stakeholders through our website at aglaw.edu.psu.edu. If you would like to learn more about a specific topic in agricultural law, please check out our agricultural law virtual resource rooms and issue trackers. Our issue trackers are similar to our resource rooms, but provide more of a timeline of developments for a specific topic. And for more frequent updates, you can subscribe to the Agricultural Law Weekly Review. You will receive a once-a-week email with all the most important updates in agricultural law. And if you would rather listen than read, you can also subscribe to our Agricultural Law podcast. Our podcast can be found in all the usual podcast streaming platforms like Spotify, Apple Podcasts, Google Podcasts, or directly on our website. And again, to get to our website, go to aglaw.psu.edu. And in addition to our other agricultural law resources, the center operates the Pennsylvania Agricultural Mediation Program, which is funded through the USDA. This program is free and has facilitated mediations between ag producers and the USDA, but also between different parties. Jackie Schweckler, one of our staff attorneys, is our program coordinator. Please feel free to reach out to her with any question you may have about mediation. So the Legal Planning for Specialty Crop Producers webinar educational series has been designed to assist Pennsylvania specialty crop producers successfully expand wholesale sales revenue with income from direct sales, pick-your-own value-added commodity, processing of agritourism, agritainment, and educational activities. And over the next few slides, I have listed the 6 topics in this legal planning series. The last 3 presentations are fast, but as I mentioned, as registrants, you will have access to those recordings. If you have trouble finding the recordings, please let us know and we will forward them to you directly. Today's presentation will be about licensing and regulatory obligations in selling raw and processed specialty crop products. Please mark your calendar for the next and 5th presentation, which will be held on November 30, 2022 at noon via Zoom. It will be about municipal law and zoning for agritourism with specialty crop processing and sales. And our last presentation will be held on December 14, 2022 at noon via Zoom, where we'll discuss PA Ag Area Security Law, Right to Farm, Acre, and Clean and Green laws for specialty crop producers. Earlier this year, we started a webinar series called Understanding Agricultural Law, a course of webinars designed to provide education on fundamental issues of agricultural law. This series is fully sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center. On this slide, you can see a list of our future topics, and the recordings are available on our YouTube channel if you're interested, but you can also register for our next sessions through the event page of our website. And before I hand it over to Brook, I would like to throw a quick thank you and note that this presentation was created as part of the Pennsylvania Specialty Crop Block Grant Program. And I would also like to draw your attention that near the end of this program, we will post a link in the chat to our specialty crop producer survey. It is a very short survey and should only take a couple minutes of your time. Please consider completing this survey as these surveys help us out a lot. Note that they are different for each webinar. If you filled out the survey for the last webinar, please fill it out again. And in a couple of minutes, we will also post a poll question asking about how you have heard about this webinar. Please note that this is different than the survey questions, so please do both if you're able to. I will now turn things over to Brook.
Okay, so again, the title of this is Licensing and Regulatory Obligations in Selling Raw and Processing Specialty, in raw and processed specialty crop products. So we're not going to talk about obligations with regard to the growing and on-farm activity. In other words, we just don't have the time to cover FSMA in this particular webinar. So just be advised that we are not covering FSMA, but sometimes some of the things that are in the beginnings of all of the FSMA rules could come into play with regard to some of these topics. And hopefully there'll be no confusion there, but I just want to make sure that you're aware of that and how that's going to sort of be an overlay to a little bit. This is really starting at the licensing and particularly the licensing from the state. This is the fourth topic in this series, and there's a sort of there's a sense to this entire series that I'm just going to go back and go over with you a little bit so that you get kind of the big picture of what we're intending to do here, which is to help specialty crop producers avoid all sorts of liability problems with the operation of their business. And those liability problems can be in a number of different, or come at you, let's just say, in a number of different ways. So let's go through that a little bit. And three different kinds of liability that could potentially arise when you're a specialty crop producer who's looking to engage in, we started this series, we sort of called it income augmenting activities, the activities that would bring in supplemental income, something better, of course, than the wholesale price of whatever commodity you might be involved with in producing. And so once you get into those extra income producing activities, such as direct sales and other things, and that's really what we're going to talk about here for the most part, you're opening yourself up to a slightly different and more expanded kind of business than what a specialty crop grower would have been, let's say 20 years ago, that even if you're growing a specialty crop like vegetables, you're selling them at a wholesale rate, you're not dealing with consumers directly, you don't have some of these potential liability problems. For the most part, our agricultural industry in the US grew up in a way whereby if you were selling wholesale, then you didn't need a license, you didn't need any type of registrations, and you weren't potentially burdened with things that could lead to liability, like dealing with the public, particularly coming onto your property or specifically onto your farm, or even if you're just selling from a farmer's market somewhere. Wholesale sales of commodities, even specialty crop commodities, prior to the advent of sort of the growth in direct sales was a less complicated thing. Now you're getting into things that could lead to liability problems. Civil liability is a form of liability where private parties might have some type of legal claim against another private party, usually based either on a contract, not really what we're going to talk about today, but on a tort liability basis also, which is the concept that people are generally familiar with. It's called negligence, which is either somebody gets injured in a way in dealing with you directly by coming on your farm, or they may consume your products and get injured in some way, i.e. by a foodborne illness of some kind. And those all generally fall into this bailiwick of tort claims or negligence claims. And, the remedy there is usually to pay the injured party something. Maybe there might be an injunction sometimes, depending on what kind of a civil liability case it is. But that's one form of liability that we created this series to address and help you steer clear of. The second kind is criminal liability. Now, criminal liability is very, very, very rare in any situation involving the production and sale of food. I'll mention one a little bit that actually came up, and if people are aware of I think it's called Bluebell ice cream case that's going on right now, that's a case where there is some criminal liability arising from the sale of food products and a foodborne illness was transmitted to customers. Criminal liability is obviously brought by the state government. It's some type of public wrong has been committed. It's that public wrong has been made a crime by the legislature, and the remedies could be fines or even jail. And then there's regulatory liability, which means you're getting in trouble. You have a problem with the government. And what we're going to talk about today here is mostly state government. Because you failed to follow some type of regulations from the government that apply to the business that you're conducting. Usually the remedies for those are like fines or some type of injunctive relief, which just means you have to do something, which is you generally correct the conduct that happened. And sometimes when you're dealing with municipal government, they'll call it like a cease and desist order. Like if you started doing business without proper zoning approval or something, you get something that says cease and desist. Again, we're not going to talk about zoning. That's coming up in one of our later sessions that Chloe went over earlier. So we talked a lot about civil liability in the beginning of this webinar series, because we talked about liability issues arising from the land. And then we talked about liability issues arising from your food itself and the specifics of dealing with those liability issues from the customer. Now, today, we're going to talk about this regulatory liability, which is essentially, in this case, government licensing kind of issues. Let me give you an example, and I'm going over this in a bit just to give you, again, the context of our entire series, because you may find that you want to go backwards and watch one of our prior webinars because it's dealing with, let's say, foodborne illness or land related claims, like somebody got injured at your property. So let's say farmer A operates a pick your own strawberry, chronically leaking manure pit discharges into the strawberry field and contaminates the soil, which gets on customers' shoes, et cetera, when they're walking the fields. And the strawberries, and of course, the strawberries themselves may get contaminated, and upon ingestion by a customer may become ill. So could there be civil liability there? Well, yes, I think we've kind of obviously sort of laid out that path. Could there be regulatory liability? Absolutely. The chronically leaking manure pit may be the obvious first issue that would potentially lead to regulatory liability. Could there be criminal liability? Very, very rare, as I said. I mentioned the Bluebell ice cream case, which I think is in Texas, and there the executives in control of that company are in fact being prosecuted criminally because they were continuing to manufacture and sell, I think, ice cream primarily, that was in fact coming out of a facility, the factory that they knew in fact was contaminated chronically with pathogens that they had not properly addressed. There was a prior case a couple of years ago called Peanut Corporation of America, which was a similar fact pattern. So that's the rare instance, and I don't want to get anybody overly concerned. That's the rare instances where something like that occurs, when somebody knowingly does something like selling food that is substantially certain to be contaminated. Okay, so negligence duties in land ownership and control, which we talked about in previous webinars in the series. There's a duty of care owed to people who enter the property to prevent them from being injured by some condition on the property. And there's a concept in negligence claims called the standard of care that's owed to, let's say, a visitor or somebody, a customer who comes on your property. Now, in food production and sales, there's a duty of care owed to consumers not to cause a foodborne illness by the intended method of consumption of the food, whatever it may be. It's interesting to always observe that we rarely sell food that is in a condition not ready to be consumed, but raw meat is obviously the one exception to all of these carefully sort of honed legal principles about the intended method of consumption. You sell raw meat, however, everyone is selling it with the anticipated premise that it will be cooked prior to consumption. And other than that, raw vegetables and fruits need to be sold in a condition that, in fact, is ready to be consumed without any further preparation. So that's just pointing out the unusual nature of our cultural acceptance of raw meat and the assumption that a customer is solely responsible for preparing it in a way and that they possess the knowledge to prepare it in a way that will make it safe to be consumed. Okay, now, there's another concept in negligence that's very interesting, which is called, it's called negligence per se, which says that if in fact you violate a law or a regulation in the conduct of your business, which then causes somebody harm, that is essentially considered to be inherently considered negligent behavior on its face. So the reason why I'm going through all this and explaining all that is because if you don't follow government regulations, which can lead to regulatory liability, as we discussed before, you can also potentially be already proving, or that conduct in committing the regulatory violation can already be the proof that in fact you were negligent. And so that's why compliance with government regulations, even as simple as licensing, et cetera, those things can lead to negligence claims very, very, very easily. So it is doubly important to make sure that you're doing everything that is the minimum required by law. And if you end up being guilty, so to speak, or you have committed things that clearly violated government standards, then the negligence case against you, if something bad happens, is that much easier for someone to assert. And your insurance company may have some great difficulty trying to defend you in that particular case. So that's really the reason I'm taking all this time to explain all this to you. Now, the basics, I don't want to leave you hanging without some basics of protection from liability. And this again goes to our entire series. Operate your business in accordance with all laws and regs and safety standards in your industry. That's kind of what we're going to talk about today in part. Go above and beyond that minimum standard of care. That's where you are essentially exceeding the minimum requirements of law, and you're doing extra things that your industry has adopted in order to protect customers. Signage for land can always be helpful. It is always helpful. Labels for food are always helpful. And also business entity formation can protect your assets. And we talked about that in the third session of this series. So you might want to go back and watch that again. Sometimes there are state immunity legislation, or there is state immunity legislation that might provide some protection against liability claims in a particular business. Some of you may be well aware of the fact that there was an agritourism immunity statute passed in Pennsylvania just last year, I guess, becoming effective last summer. And now that does not exist, and that particular statute or that law does not apply to the service of food and beverages. So there is no benefit to you from those things with regard to a foodborne or a beverage-borne illness. Now, liability insurance. that we probably should have had a separate topic and a separate hour-long webinar just on liability insurance. But maybe we will supplement here in the future. We covered that a bit in the prior sessions. Now, let's talk about what we're here to talk about today, which is licensing and regulatory obligations from Pennsylvania state government, not including FSMA, that's federal government, in the process of selling raw and processed specialty crop products. And what we're going to talk about for the most part is the things that the Pennsylvania Department of Agriculture's Bureau of Food Safety enforces and their administration of various state laws. By its very name, Bureau of Food Safety implies just what it does, which is its job is to ensure food safety under, or at least enforce the Pennsylvania laws that exist to address food safety. And there's a little blurb here that tells you about that. Now, if you go to their website and their homepage, it sort of tells you the various sort of subtopics that are encompassed by the Bureau of Food Safety and its website. Milk and dairy product permitting, an entire regulatory scheme that we're not going to talk about. It's not a specialty crop product. Eggs, not going to talk about those either because they're not specialty crop products. However, fruits and vegetables, yes. Retail food inspection reports, yes, we are absolutely going to talk about that because that is a key for, and right below that is retail food regulation. That's what we're going to spend a lot of time talking about because that is in fact it fully encompasses the selling of raw and processed specialty crop products. There's a laboratory division that does lab work for the Bureau of Food Safety, which is all important, but we don't need to talk about that today. Food manufacturing, yes, we are absolutely going to talk about that because that's sort of a part of selling, particularly the processed specialty crop products. FSMA, again, not going to talk about that. We see consumer protection, that's a general category here, and food safety complaints. This is the entity, of course, to which the public goes if it has some type of a complaint. This is the way that the Bureau of Food Safety is divided. So if you're looking to deal with the Bureau of Food Safety, you deal with the people in your various regional offices. This is how the state is all divided up here. So that gives you a little, and most of these documents and things I'm going to show you are available on the Bureau of Food Safety's website. These give you the supervisors and the people to contact in each area. So these are going to be your friends. There is no way to be in the business of selling, or I'll put it this way, there is no way to be in the business that's of selling direct to consumers, particularly without dealing with the Bureau of Food Safety. You can't hide from them. You can't get around the systems. You're going to get into some serious hot water if you attempt it. And these are the people that are going to save you from the problems. And I hate that, people laugh when they hear things like that said. And people may very well know that I was 12 years, I was an employee, an attorney at the Pennsylvania Department of Agriculture. But the bottom line is the best way to stay out of trouble and to make sure you're compliant with what you should be compliant with is to make your food sanitarian one of your best business contacts, because they're the ones who are going to answer your questions for you and make sure that you have the right things that you need and that you're doing things the right way. And that is their mission. And I just, people like to scoff at the idea and the old phrase of I'm the government and I'm here to help you. But in this case, there is no way you're going to engage in particularly direct sales without making those people your business partners, so to speak. Now, everybody knows the Bureau of Food Safety, or most people know, that they can have a publicly available inspection report database. And this is a database of all inspections from any entity that holds a retail food facility license, which we'll talk about in a little bit, which is a restaurant, or anywhere that ready-to-eat foods may be sold, as well as anybody who is just manufacturing food in some capacity and selling it even as fully packaged. In other words, not necessarily ready to eat. and anyone who is simply selling prepackaged food that maybe they didn't even manufacture. All these inspection reports, stores, restaurants, farm markets, small, retailers, all their inspection reports are available for the public to view on this particular database. So this is an open book. This, when you get into this industry, and you have to understand that and know that that's the way you have to conduct your business. Okay, the primary laws enforced by PDA that would be applicable to a specialty crop grower, the Retail Food Facility Safety Act and the Food Safety Act. A general way to understand why there's two different laws and what they govern is the Retail Food Facility Act, Safety Act, deals with anytime that you are selling food to the public, and the Food Safety Act provides a lot of general administrative provisions that deal with this subset of people who are retailing food, and also has a separate category for what are called food establishments, which may be either manufacturers of food, but not sellers to consumers, or it may just be facilities where food is stored in some capacity or in some way. So depending on how you're operating your business, your barn could end up being a food establishment, for example, and it's subject to some of the registration provisions under the Food Safety Act. So the regulation, those are the two laws. Pennsylvania then, and every jurisdiction has this category of things that are called regulations, which are fleshing out the laws and provide the details of what the law is, either how it's interpreted, how it's enforced, et cetera. And that is essentially the PA Food Code is the word for those regulations, the detailed regulations that the department has put together with regard to enforcing these two laws. And there is another thing called the Model Food Code, which is a FDA published code, which is adopted by states in their own time, in their own way, and they may modify it slightly, or they may adopt the Model Food Code in wholesale, just the way it's written by the FDA. And in Pennsylvania, almost verbatim, the Model Food Code has been adopted. We do have some provisions in the Retail Food Facility Act and the Food Safety Act that slightly provide some extra or might slightly differ from the Model Food Code, but not all that greatly. And the good way to understand it is the the FDA and the Model Food Code, these things govern basic food safety practices, particularly in the manufacturing end, where the FDA actually may have jurisdiction over a food manufacturer, but the retailing of food is purely a state function. So there is no, well, I'll leave it at that. Let's just put it that way and say that, the FDA doesn't get into talking about, how a food store or a restaurant, is to be run. FDA is maybe getting into food manufacturing regulation, depending on the size and what's being made. All right, these are little tables of contents of the two laws. And I put them up here. As an attorney, it looks to me like, hey, they're pretty slim. They're not very extensive. That may not be your impression, but the bottom line is, they really are not very extensive state laws. And that's because a lot of this Model Food Code comes in from the federal level to govern real specifics, like the temperature of this and the way that you must handle this particular food, and et cetera. There's a lot of that detailed food safety stuff that's beyond me as a lawyer that is in the Model Food Code. I'm just going to tell you the larger picture with regard to licensing and what you need to do to comply and obtain and comply with your license. So the Retail Food Facilities Safety Act, I'm going to butcher that again if I don't get it right. The Retail Food Facility Safety Act is the right thing. And I was around as the chief counsel at PDA when these were enacted in 2010, and we did a complete transformation of Pennsylvania law to come up with these two rather slim laws now that incorporate the federal model food code provisions. What's a retail food facility? It's basically, okay, this gets a little complicated, but it is a public eating or drinking place, which is a restaurant. That was an old term that they've just kept around for the purposes of the definition. Or a retail food establishment. Okay, what's a retail food establishment? That's where the meat of this definition goes. A retail food facility is a retail food establishment, which is an establishment which stores, prepares, packages, vends, offers for sale, or otherwise provides food for human consumption, and here's the key, and relinquishes possession of the food to a consumer directly or indirectly through a delivery service, such as home delivery, or any other means, or of course, it includes handing it to you in bags when you leave, when you check out. So that's a retail food facility or a retail food establishment. So that includes every grocery store, every retail store, every restaurant, every snack bar. I mean, this includes, I have a habit of doing that sometimes. Okay, this includes just about everything. The only thing it doesn't include is manufacturing facilities where possession of the food is not delivered to a consumer. And those, and that may be what you are operating depending on what you're doing. Term does include dining cars, okay. And there's a little extra sentence at the end that we don't really need to be paying attention to. So the bottom line is, if food is being turned over into the hands of a consumer in any form, or made to be eat, a hot dog, whatever it may be, then that is in fact a retail food facility. What's a food establishment? Okay, that's the other category where the consumer is not taking delivery of the food from that entity or at that site. And this is a room, building, place, or portion thereof, or a vehicle maintained, used, operated for the purpose of storing, packaging, making, cooking, etc. You see all these, all of these verbs here that are included in there. It could be just a food, could be just a truck, that holds food. Now the term excludes retail food facilities. So in other words, not the restaurants and stores. Or anybody operating under milk license. But okay, so that's the difference. So you got retail food facilities and you have food establishments. Very important terms under Pennsylvania's licensing scheme. And the thing to look for is you might need to be registered as a food establishment, which is a registration, as you see here, and not even really realize it. Or you might have multiple locations, some of which are food establishments because they're just storage and they need a registration, some of which you're delivering possession to a consumer and they need a license. So they are two different things even. Now, what does this mean? You pick up an old piece of baked goods, we've all seen this, and it says registered Pennsylvania Department of Agriculture. What does that mean? It means absolutely nothing. That is a leftover of a bygone era, and that is before my time, and before the time of anybody who would be on this webinar. And in order to accommodate the fact that companies blindly use this, and you'll find companies from California that blindly put this on a little snack cake or something, or some type of product, and they don't know why they're doing it, and we don't know why they're doing it. But it was a vestige from a long, long time ago. And the bottom line is, in the new law, we just incorporated this thing that said, okay, the secretary can promulgate regulations regarding how this food, I should say, the use of this particular text on food. So it's been addressed and mentioned in the law, but again, it is not a requirement of any law anywhere ever. Or at least I'll put it this way. It's not a requirement of any law anywhere in the last maybe 40 years. I might be, it might be longer than that, actually, to be honest with you. So it's just an interesting quirk. Okay, retail food facility license exemptions. That's the important part. Okay, who doesn't have to get a retail food facility license, even though they are delivering food to consumers? Well, when I was at PDA, we used to call it the church pie or the church bake sale type of stuff, and those sorts of things. Now, the exemptions, but I'm going to go at the exemptions in a little different way so you get them perhaps more clearly. A person may not operate a retail food facility without a valid license issued by the department in their yearly licenses, except otherwise provided, unless otherwise provided in subsection B. Okay, what's B? B says that you don't need a license if this is all you're delivering to consumers. A retail food facility in which only prepackaged, non-potentially hazardous food, which means no meat, no dairy, is basically a good way to look at that, or beverages are sold. And this is the key one, a retail food facility that sells only raw agricultural commodities. So you can have the biggest farm market you want, but if you're only selling raw agricultural commodities, your specialty crop commodity, let's say, or commodities unprocessed in any way, you can have the biggest retail store ever, but you don't need any kind of retail food facility license because it's only raw agricultural commodities. Same thing with the prepackaged stuff, but it can't be prepackaged foods that have meat or other proteins, animal proteins, let's say, or any type of a dairy product. It's basically, the actual acronym is time and temperature controlled. So it's something that is going to spoil at some point in time. And in today's world, additives to baked goods have rendered even butter not necessarily within that category, depending, but of course, all these butter substitutes have kind of come up too in the last, decades to try to take products out of the category of potentially hazardous foods by using something that won't spoil. Okay. Also, so those are the two main categories. Those apply forever or, universally everywhere, every corner of the state. Now, there are some more exemptions that can apply by the order of the Secretary of Agriculture. And in 2010, there was such an order. I think it might have been 2011 until we got it out. But anyway, now, there's also this provision, and this opens the can of worms, which says a retail food facility is exempt from licensure by an order of the local government or units having licensing authority. It's like, wait a minute, there's more than just PDA involved? Yes, there is, because there are such things as county and local health departments. So all you should do is go to the spreadsheet on PDA's website. If you happen to be in one of the jurisdictions that has a county or local health department, then they become the entity that enforces this law and issues the license, not PDA. And it's a little bit of a patchwork in the state. Here's an example of the counties that have their own licensing system where PDA does not operate are Allegheny, Bucks, Chester, Delaware, Erie, Philadelphia. Major municipalities that operate their own retail food facility licensing where PDA does not end up being the licensing jurisdiction: Reading, State College, Chambersburg, Scranton. You can see the list there. There's some fairly large, municipalities in there. So that makes it a little more difficult for you when you're trying to plan, because you have to make sure that maybe you're not in one of those. And if you're in one of these, then you got to deal with them and them only on a retail food facility license. Okay, not a food establishment registration, that's still PDA. In other words, think of it as sort of the manufacturer or the warehouse. That's still PDA jurisdiction everywhere in the state. Okay, now, again, here's the statewide apply everywhere exemptions. Raw agricultural commodities and only prepackaged non-potentially hazardous foods. All right. For example, I'll leave vending machines and sandwiches with meat products in vending machines out of this discussion for now. We maybe get back to that. But now, PDA's additional exemptions, besides the two that I just mentioned, operate no more than 3 days a week, or you're a food bank operated by a charity, a soup kitchen operated by a charity, other charitable nonprofit entities that are supporting essentially recreational activities for youth. In other words, the soccer moms and the auxiliaries for supporting the football team or the band or whatever it may be, and food and beverage sold only through a vending machine. Okay, and in other words, in the situation where you have a meat product in a vending machine, that is on the seller, whose name is prominently displayed on the vending machine, and there isn't technically a retail food facility license required, even though you might have a vending machine with meat products or meat sandwiches, let's just say, and school cafeterias. So now, if you're exempt from licensure, it doesn't necessarily mean you're exempt from inspection. And that's a whole nother story, which we may have time to talk about. Now, here's your friends. These are the application packets to get the various types of license applications that you need from PDA to operate any kind of a retail food facility. Again, if it's raw agricultural commodities only, you don't need this. If it's anything other than that, you're going to sell somebody's canned beets, or you're going to sell, some kind of baked goods or anything like that. Those aren't raw agricultural commodities. Those are processed, and so now you're going to end up having to get a retail food facility license application. It's a detailed application, but it's a good one. And maybe that's because I had something to do with it. But the bottom line is it's thorough, and I don't think that it is all that confusing. There's one for a standard, opening. There's one for changing of ownership. There's one for remodeling. There's even one for shared facilities where you're sharing a kitchen facility, let's say, or you're sharing a retail space where you're serving, ready-to-eat foods or any type of, food that isn't raw agricultural commodity or a prepackaged to consumers. Okay. Here are the big requirements that can run into trouble. Depending on what you're doing, you might need a HACCP plan. Pretty rare in a retail food facility. The water requirements, you do have to have proof of either public water or DEP documentation and some testing results if you're working on some type of a well. And there's also sewer components here. And here are the license fees. Now, this is a little chart that shows you when a HACCP plan is needed. A HACCP plan is only needed if you're doing something very unusual as part of this retail food facility, such as any of the things that you see in this little diagram. HACCP plans are pretty technical, and that's really beyond the scope of this presentation. They're more come into play in the manufacturing context, but we will talk about that in a minute, there is a substitute for the HACCP plan in the manufacturing context. Some restaurants and some retail food facilities do engage in these kind of activities themselves, making their own products in some way. And so that just gives you an idea of when it gets more complicated, let's just say. Okay, now PDA's website has all kinds of nice flow charts and things that give you direction on labeling requirements, because you still have ingredient labeling. If you are preparing anything, or if anything is processed that is not a raw agricultural commodity, it may need certain ingredient labeling. So there's all kinds of materials on their website that explains that to you. There's some other, there's some sampling guidelines in there, because if you're at a farmer's market, you're going to do sampling, kind of tells you how to do that safely under your license. So that there's a lot of good resources there. Now, food establishments, this is more the warehouse, the manufacturer. Here's the application link. Again, my PowerPoints are always packed with the links to the documents that you need. Now, the key thing to understand about the food establishment registration, one is that you might have one and you don't even know it, because you're using some part of other buildings for storing things that you then later take to the farmer's market, let's say, and that can become a food establishment. Or you may end up, if in fact you are doing some type of, manufacturing process where you're not selling to the consumer. Like if you're just doing wholesale, baked goods that go to some retailer for resale, then you're into the food establishment arena. And most of this is governed by the incorporation of the federal standards from the Code of Federal Regulations, the FDA's regulations with regard to the preparation of human food, and they're called Good Manufacturing Practices, GMPs, for human food standards, and that's essentially how the food manufacturing industry is regulated. And you have to work with you have to go to the the FDA website, and you have to do a little bit of work to figure out whether your particular manufacturing process is going to be FDA regulated. And the best person to help you do that is your food sanitarian. So let us keep moving, because I do see I am already sort of up against the 15-minute remaining time here. Now, there are other types of establishments in Pennsylvania that are creatures of state law that, besides the retail food facility and the food establishment, which we do need to mention so you understand how the big picture works. There are limited food establishments. This is the classic home kitchen type of food manufacturing. And again, the food sanitarians from PDA are the ones who will direct you through this process as to what you need and how you need to handle things if you're going to be producing something for sale to consumers out of a less than manufacturing grade type of kitchen. It's and hundreds of people are doing it, and it is not in any way, shape, or form insurmountable. But that's what you're called then, a limited food establishment. Hit this link, and you're going to go right to PDA's resources on all of that. And it's fairly once you start working through it, it's not as complex as it might seem. Here's a couple of the instances where it would apply. Warehousing food on a residential property. In other words, like I was saying, if you're storing food that you later take to the farmer's market, for example, that may very well be a limited food establishment. Now, it's raw agricultural commodities, it's not. But if it's something else, then like let's say you're storing baked goods somewhere, you got to store them someplace. So that may be within the limited food establishment, and you may end up having to get that registered. And then, of course, processing food in a home residential style kitchen, you might have to do some modifications. And also dealing with, things such as preparing food that you're then going to take to some type of a church, fire hall, etc. Okay. Now, there are also, of course, mobile and temporary food facilities, whether it's food trucks, whether it's, stands at a fair, all of those kind of things fit into the bailiwick of mobile and temporary food facilities. This is just like the limited food establishments were a subset of a food establishment. These are a subset of retail food facilities. So they are a creature of state law with slightly different standards that apply. They're not, the FDA has never written, provisions with regard to food trucks, et cetera, or even these, again, this limited food establishments, the sort of home kitchen thing, FDA, you got volumes and volumes of FDA regulations. These have never once mentioned. They are purely a product of state law allowances. Same thing with the mobile and temporary food facilities. And so those are also governed by the same outfits, just as a subset of a retail food facility. And you walk through these application packets, and that's where you get all your information. Essentially, there's a 14-day sort of bright line test with these types of facilities that if you are if you're parked in the same place, even if you're not open the entire time, if you're parked in the same place for 14 days of the food truck, you end up becoming disqualified from being a mobile unit. In terms of a temporary stand type setup, you can't be more than 14 days. consecutive or non-consecutive again. So some people push it with their temporary stands. If they go over 14 days of the year, they no longer qualify. Okay, the farmers markets, this was a big change in 2010. Used to be that there was just one license for the entire farmers market, whether you had 10 vendors or 50 vendors. Now every individual vendor has their own retail food facility license. But of course, accommodations are made for the fact that you don't always have a public water supply, et cetera. There are all sorts of provisions in the application package you can read to understand how you meet the requirements for a retail food facility in your farmer's market stand. And again, it all depends on how much sort of cutting of food and touching of food that you're doing there. The more you arrive with everything prepackaged, the better off you're going to be, of course. Okay, now, this is sort of a rundown of the general, what they call the retail food program, which is the package of things that PDA's staff does in this area. We talked about almost all of these. If you're making frozen desserts in any way, you have sort of a separate law that applies to you that you got to make sure that you're either compliant with or it doesn't apply to you. Now the big one is food employee certification, and that applies to retail food facilities. That's a requirement of retail food facilities that I didn't get to yet, and I will get to it right now, which is every retail food facility must have a certified food employee who has obtained that certification from a nationally recognized food manager course that they take, and they have to post the certificate on the site, and they have to be available during all hours of operation. They don't have to be physically present, but they need to be available. And there's a nice course listing on PDA's website that tells you where you get your person certified. The big issue in this really becomes, turnover of employees. And if you lose your certified food employee who has taken this advanced training, you got to get another one, and you got to do it quickly. You get 90 days to substitute if the employee leaves. So you have to think that one all through. There are exemptions to the food employee certification. Retail facilities where only commercially prepackaged food is handled and sold, okay? Retail food facilities that handle only these non-potentially hazardous foods, time, temperature controlled. In other words, the issue about, you can have baked goods, but they can't have, meat or dairy products in them. Okay, food manufacturing facilities don't need a certified food employee. And then there is a tax exemption and for a retail food facility that is run by a tax exempt organization, and also by just a standard nonprofit that may not have the IRS tax exemption. Okay, last slide, and I'm actually early. I'm amazed. I sort of rushed, but I wanted to make sure that we got through here. Sales tax licenses. This is an unavoidable and ironclad requirement. Every single license and registration, in other words, a retail food facility license or a food establishment license of any kind from PDA, requires you to have proof that you have the appropriate sales tax license. You can't avoid it. You can't get around it. You just have to do it. And so I just put in here, read it, know it, get it. And this is the link. And there's a really nice publication that the Department of Revenue puts out called Starting a Business in Pennsylvania. And it goes through and walks you through, exactly how to get a sales tax license, how to compute the sales tax, et cetera. And so I'm no sales tax expert, and you may never sell a product that needs it, but you're going to end up having to get it. Just in case you expand your product line. So that is something that is completely and totally unavoidable. So it goes with the theme that the PDA staff is going to help you through this process. In this particular instance, you need to really work closely with them, and you need to disclose all aspects of your business to them so that they know what you're going to be doing. This is not an area where you can take shortcuts with information or any other requirements for that matter, because it's going to end up biting you in some capacity down the line. All right, thanks everybody, and we can take some questions now. Do we have any questions?
Yes, Brooke, we have one question.
Okay, let's go. Yes. Oh, okay. Well, this PowerPoint, yes, being available for immediate use. I think, and the links are, active. Yes. Jackie, you might be out there. Is this uploaded yet to our website? I think the answer is yes.
Yes, it's available right now.
Yeah. Okay. So I could probably, even since we have a second to do it, I might even be able to show you how that works. There we go. Okay. So if you go to our website, and I'll do it this way. Give me a second. All right. So this is the home page of our website. If you look through here, and the easiest way to do it is this is a little round robin or a carousel of different webinar series that we do. If you go to this one, Legal Planning for Specialty Crop Producers webinar series, and you go to the Learn More, you're going to go right to our landing page for this particular webinar series. And then you can scroll down and you can see all of the past ones that we did. And you can watch them, or you can look at this, or you can get the copy of the PowerPoint slides. So here is our first one on liability arising from business invitees, in other words, from the land and people getting injured on your property. This is our second one was on the sales liabilities, in other words, foodborne illness. And then the next was on business structures to protect you. Again, click on the first link and you can watch it. Click on the second link and you can get the PowerPoint slides. And here is today's, are we in the right place here? Yeah, here we go. Yeah, it was just all of a sudden occurring to me. It's already November 16th. Here are the PowerPoint slides. You click on that link and boom, you're there. And here they are, right here. So they are available for you. Okay. All right. I think the most important thing to take away from this entire, webinar is that you basically have two types of requirements that will lead you then into all of the other requirements for the basic compliance with minimum standards in Pennsylvania, or according to Pennsylvania law, which does in fact protect you from a negligence case based on the fact that you didn't follow the state's regs. And those two types of facilities, again, are retail food facility licenses, where you are delivering food to a consumer, or a food facility or food establishment license, which is a license where food is either manufactured or stored, but there is no delivery to a consumer. So those are the manufacturers and the warehouses, and then the retail food facilities is everything else, whether it's the tiniest little snack bar up to, the most ornate grocery store, or most, ornate and fancy restaurant. And again, the big exemptions from the retail and every farm market for that matter, unless you're sticking to raw agricultural commodities, or completely prepackaged food that has no meats or proteins or other products that can spoil, then that's the only exemption that you have from the retail food facility license. Most of the farm markets that we all grew up patronizing and that may have been operated in the past generally were coming in under the raw agricultural commodity exemption, and many of them, of course, still do. The 2008 changes, where everything got sort of recodified in Pennsylvania, created this issue where individual farm market standholders had to be licensed if they were not within the exemptions. That opened up a bit of controversy. I think the state has kind of gotten used to it all. The larger farmers markets with multiple vendors have adjusted. The stand orders have adjusted. It can impact what you're going to sell, but I don't think that the requirements really turned out to be all that burdensome in the end. And we certainly do have a much better way of tracking things and accounting for things now that we have individual stand holders actually holding individual licenses. Okay, with that being said, we will sign off. Thank you everyone for attending. I think in the 4 webinars so far, in total as a package, can really help you out in your business. Thanks for attending today. And then we have 2 more coming up, which I think are also going to be very helpful. And then if you register for these, then you will receive a package from us when we're done that will have all the materials in a booklet format that won't just be PowerPoint slides. So thank you, everybody. We will see you at our next webinar.